Man, it's only 3:01. What up, everybody? Excuse me. I had to get my voice together. Alright, let's check out some. What we wanna watch today, man? What up, everybody? It's LhCapoTv. We're back at it. Let me see. Trending. Yeah, it's fun to see what's out here. Sheesh. Young boy, stay trending. I'm not gonna play no music 'cause I ain't really trying to get, hit with that copyright. You know what the problem is when you're trying to stream? That first beginning, that first stage of streaming, man, that jump be hard. I ain't gonna lie to you. Just learning it, building confidence, building consistency. Like, shout out to the people that's doing this, man. For real, for real. Like, if nobody's congratulating you, man, I want to congratulate whoever, man, woman, child. Like, this is not something easy. It builds a lot. It's like a character thing. Like, people will sit there and joke and laugh at you when you go out in public, and just to be able to do that, that is serious, like, bravery. On a serious note, that is serious bravery. And shout out to everybody, man. For real, for real. Shout out to everybody that's doing it. Shout out to everybody that's, trying. Cause boy, it ain't easy. This junk ain't easy. Seriously. This junk ain't easy. I gotta figure out how to lock the see how I keep switching from page to page and junk? I gotta figure out how to lock the screen. So I don't do that. You know? I don't do that, man. But yeah, man. We here. About to start. I just been rambling. Let's start it. What we got for today? What viral? Poppy playtime. What is this? This junk looks scary. Investigating our best friend haunted house. 2.9 million views in 2 days. Sam and Kobe. Sheesh. Meet my daughter Ava. Second channel, boy. And they getting these type of views. Shout out to them, man. R-Truth jump by Judgment Day calling out Damian Priest trying to kick out JD. Hey, you know what's crazy? Art Basil is just here, and my friend had hit me up and like, oh, we out to Art Basil and make some content. And I'm like, I ain't even respond. See, that's the thing I'm talking about, like, just trying to build that confidence to do this. It's not something easy. Serious, on a serious note, it's not something easy. That's why I like shout out to all the people that's doing it. You know, shout out to them, good boy. And just trying to do this ain't easy, man. So I'm gonna just keep on putting content out. I just been rambling. I know, like he just been talking, but I gotta communicate. You know, I gotta get y'all side of me. You know, gotta show y'all, like, I know there's nobody watching right now, but hey, later on, people gonna look back and see like he has the same characteristics that he first had when he first started, and it didn't change from 5 to 10 years from now when I'm like the biggest, you know. Like one day I want to be as big as Mr. Beast and surpass him. You know, right now I don't have, you know, the same knowledge as him on the capability on what to do, you know, like just starting off. So I'm trying to learn how to even make my own videos, edit everything, have my sound like some type of quality, you know. So it's like just trying, you know. So as long as I be more, I'm trying to be more consistent with this, I could do this, you know. But let's get back to this, man. Let me see. Yes, CM Punk chooses brand. Confront Seth Rollins. WWE highlight. WWE Raw highlight. You know what's crazy? When I was a kid, WWE was my thing, man. Undertaker, Batista, John Cena, Booker T, Rikishi. Oh man, Eddie Guerrero. Oh man, Rey Mysterio. I remember when Batista came on, not Batista, but Brock Lesnar. When Brock Lesnar came to WWE. Yo, man, that man destroyed WWE. Eddie Guerrero came in. Damn, dog. Damn, RP Eddie Guerrero, man. For real, for real. And that was crazy, man. Cause man. Ain't nobody could beat Brock Lesnar, man. He was just dominating them boys. That was a good look. Like whoever created that idea, shout out to them because that was wonderful. How much trouble are Jalen Hurts Eagles after 13 and I'm talking about 33 and 13 loss versus the Cowboys? Ooh, Lord. They ain't got nothing. Giant Minecraft machines are assembly simple. Best Lego Fortnite tips. I'm not a fan of Fortnite. Keep it honest truth with everybody. I feel like, I don't know. It just ain't for me. It's not my boat. It's not my cup of tea. You know? It's not a thing that I like. You know? But man, I gotta figure out how to work this YouTube jump. Not even a YouTube jump, this streaming jump, man. It's pretty decent. It's not bad. It's not hard. You know? Just gotta keep up with it. Gotta keep up with it, you know? Then they got that Instagram live. Yeah. You gotta do all of this just to you feel me? Try to blow up. Dang. We live in a world. I had nothing to do today, man. I was like, I could either sit home and just watch TV, or I could just put on, like, get on this internet and try to do some content, you know? Will Ferrell goes sneaker shop. I wonder what Will Ferrell like. You know? I wonder what the Will like.
Oh my God. Incredible. And they're all mine. What? They're not? Oh.
Hey, you got me too. I literally thought. Yeah, no, he got everybody.
Joe, is that you? It's me. You know, what's my
Excuse me.
pants? You're not, it really is you. It's not AI. Let's go shopping.
I like how I was able to figure out that background jump. I ain't like that.
producer, and all around Hollywood legend, Will Ferrell. How you doing? I'm doing great, Joe.
Yeah, Will Ferrell getting old.
That's okay. That's okay. He's a secret though. See what he's feeling, what he's not, and then hopefully for the device of sneakers. Looking forward to it. Let's go. Will, I want to take it all the way back. Obviously, we're in like the Jordan 1 section.
Yeah, man, be talking and talking. Ain't nobody trying to hear all that. Charleston White comedy fight. But Charleston White go around fast. And he make, well, I'm telling him. One thing about this dude, he learned the internet, boy. He, shoo. He hit me straight like that. John took off. See, you know, they learn how to do that content. Feel me? It's all about that. I don't know why people post guns on the internet. Candace Owens.
There is a social media influencer known as the Real HRH Collection. And she had a very controversial take, or I guess some controversial advice for ugly women. Let's hear her in her own words on the Sarah Fraser podcast. This young woman's name, by the way, is Alexandra Pierce. Take a listen.
You will tell people if they're ugly. What can someone do if they're ugly? I've said this, I know it takes too long to respond, but I'm telling you, go to college, you have to go to plastic surgery. You will end up finding someone who loves you and wants to be with you. You will love yourself, but you do not go to college. Woke loser, no man wants a woke woman. No man is attracted to a woke ass woman. Go get your face fixed, get ready, and get married. Get married. Move out of the cities. That's the truth.
So what do you think, John?
Yo. Oh my gosh, man, we live in a world that people actually think like this. Oh. Oh my gosh. And I have a daughter, I hope she don't think like this. Like, seriously, like. It's ridiculous. And people don't understand, like, yeah, you gonna look beautiful for a time period, but beauty is like, it's like, what can you bring? Like, nobody wanna take care of nobody that can't bring nothing. Yeah, it's a man's duty, but it's like, man, being a man, wow, stressfulest thing in the world. Stressfulest thing in the world, cause you gotta, like, it's like, I understand taking care of somebody is part of being a man, but nobody want to take care of a bird brain, you know?
Guys, do you agree? Do you disagree? Do you said invest that money in how you look? They're kind of divided on what you say. I'm not so much divided on what you say because she is kind of summing up a lot of what I have said on the show. First and foremost, she is correct. Men do not like woke women. That is one of the biggest lies of feminism that you are going to somehow.
Nah, I ain't gonna lie. What is woke? Woke. What is woke? Woke is an adjective derived from African American vernacular English meaning alert to racial prejudice or discrimination. That's what woke is. Alerted to and concerned about social injustice and discrimination. Oh, wow. Oh, wow. That's not true.
And he's going to be attracted to you. No, because if a man was attracted to a man, that would make him a gay man.
That is true.
You're a heterosexual man, and you are actively part of
Like, as a man, all the person want as a man is somebody that does not lie. I know lying is a thing that humans do, but a person prefers that the person that I'm choosing to spend my life with can be as comfortable with me to just be honest, communicate. You know, if you feel some type of way, say it now, not later. You know, and just learn to have like be you and don't be me. Like a lot of problem with women, they try to be they men, and that be the problem. Like just be you, do you, and sometimes doing you will just make the relationship so much better.
The yin and yang that we're looking for. Men are looking for women to be softer, to bring in things into a relationship that he can't already offer. And it's definitely not going to be wokeness that men are after. They actually like to pursue traditional women. And some women find that out way too late in life and they end up quite miserable. So I agree with this. You go to college nowadays, get a woke education, you become a feminist, you become a radical, you shave half your head, dye part of it purple.
Yeah, that shaving head, yeah. That is a okay.
Only just not going to be good.
That is a 2 thumbs down.
That you are a woman, you know exactly how you want to find the parts of life, you want to become a doctor or a pediatrician, great, go to college. But for the women that are there and you're taking, fashion.
Hey, woman, ladies. I love me a doctor. I love me a pediatrician. I love me a woman that's out here chasing their dreams to be something successful without a man needing them or using a man or having to use sexuality or use their body to further their pursuit. Because at the end of the day, it feels better when you know that man ain't touching.
Courses or studying together, studying is actually so degrade you over time, actually. If you think of yourself as a stock, it is just going to degrade you over time. And so I agree with her. Don't go to college. Don't be wasting time now. Whether or not you should instead take that money and invest it into plastic surgery, don't know that I necessarily agree with this. I think that if you're not that attractive, but you have an amazing personality and you have so much more to offer, like I thought men are looking for, and there are women that are loving, women that are kind. I always say that way to a man's heart, you stomach women that have skills and household, be able to cook. I mean, come on, you're finding a husband. No question about it. When people and women are mixed.
That cooking thing, so important. But women don't understand it. They don't understand. We go hunt, bring the food back, and you cook. And it's the time I'm in from eating, pooping, and sex. Women always cook. I know it sounds, or whatever that word is they use for people, that like a terminology I'm trying to give, but man, it is so true. Women can cook. I guarantee it. And I know it's not like some men, they just don't know themselves. So they gonna be out here just whoop, 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 all types of women. Because honestly, some men don't know themselves. They searching for something that they can't find. And that's all it is. But when a woman can cook, oh Lord. I'm talking about real cooking, surprise cooking. Like, you be like, what, you made it? You know how you know that? What, you made it? Yeah, she made that.
Miserable and how to practice that. So if you do decide to
Baby, she made that.
not
God.
get AI based,
Hey, thank you for the 2 views. Appreciate you coming, man. Keep giving me some new views, man.
That I stand is when women have really, really, really bad hook noses. I think if you have the money, you get it fixed. Like I have seen so so many of my friends have gotten nose jobs. I'm not talking about the perfect nose. Nose type of character, very nice. Everybody has a nose.
You talking about white people? Yo, bruh. She talking about white people like, yo, you got them long nose. You know, I ain't gonna say that word. You know that once you use that word, you know, we become a beep, beep. And I'm not trying to, you know, I ain't trying to deal with that. We live in a world where you can't even say nothing, so it's just better to just be respectful to everybody, you know. Instead of you being disrespectful and bashing somebody, it's just better just be respectful and move on, you know. But sometimes I do be wanting to give my little opinion. Your opinion, it's like your booty. Everybody got one. Everybody got a booty, and everybody got an opinion. Well, and they always talk every interview. Ooh, ooh, ooh. They got more stories and stories. Mm. Why do they do that? They come, I feel them. Let's see. Let's read this right quick. There it starts. In 2019, Hannah Paint witnessed a hit and run accident. She called 911 to report the crash. Instead of following instructions from the dispatcher, she allegedly followed one of the drivers involved in the crash, Kenneth Theron, in the manner he returned to the scene. Payne Dan allegedly fatally shot the man that he just sat in the driver's seat of his car. The 25-year-old is charged with manslaughter, 2 counts of felony murder, aggravated assault, false imprisonment, and 3 counts of possession of a firearm during the commission of a crime. Yeah, like, what the hell is wrong with people?
Interviews was disseminated by the media, and as we heard earlier this week, once personal information is put up, then there are people that make calls that are, you know, aggravated, annoying, not positive. And so I would just kindly ask the media not to republish any information as personal to the defendant or to any other witnesses in this case, so as to avoid calls being there not wanted. Where is the state ready to proceed to this?
Somebody said the judge definitely smokes weed. Oh man, people are hilarious. I understand what, girl, you done cause all types of trouble. People be out here doing all types of things. No care in the world.
State would exclusive. I mean, not that it had anything to do with it. For my entire life until I was 18 and my grandfather passed away, I was going to be a police officer. And on May 7th, 2019, she got her opportunity. And as a result, 52-year-old Ken Parent, who's unarmed, and minding his own business, was chased down, detained, shot,
Just out your car. And the principal is crazy. He didn't know her. He didn't know why she didn't approach the car. And demand that they do anything. He didn't have to listen to her. He didn't have to do anything. As he continued to ask her, who are you? It got nasty to come here and take that stand and blame everybody else. Now, before I jump into all the evidence that you heard today,
That jump crazy.
here to be a fair and impartial juror, honestly seeking the truth. And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth. You have a duty to follow the law, and you are bound by the instructions and the law given to you by the judge. Now, you shouldn't consider anything that's outside the circle. Passion, public opinion, dislike of the police, any sentiment, sentencing, prejudice, penalty and punishment, conjecture, whether you disagree with the law or you have any sympathy for the defendant. The only thing you should consider is the law, the elements of the crime I'm going to discuss with you, any testimony that you heard during this trial, any expert testimony, and you will determine the credibility of the witnesses. Any photos, any audio, any video that you saw, the physical evidence, and your common sense. We don't ask that you leave your common sense at the door. And any corroboration. Now, you do have a duty to deliberate. And if a juror refuses to deliberate or discuss with the other jurors the evidence or the law, you may bring this to the attention of the judge. Now, let's talk about the legal part. Now, you heard a lot about the presumption of innocence. Now, the presumption only exists until it's overcome by the evidence. So, once you believe the defendant committed the offense as alleged in the indictment beyond a reasonable doubt, the presumption is gone.
It's a beautiful black lady.
Beyond a reasonable doubt. And we take that burden very seriously. Now let's talk about reasonable doubt. Reasonable doubt is not proof to a mathematical certainty, or proof beyond all doubt or absolute certainty. There's no number. It is beyond the doubt of a fair-minded, impartial juror honestly thinking the truth, and it is based on common sense and reason. Now, there are two types of evidence. You have direct evidence and circumstantial evidence. Direct evidence points immediately to the question at issue. So, for example, any witnesses that testified based on things they saw, things they heard, things they smelled, tasted, anything of that nature. That's direct evidence. Circumstantial evidence is proof or facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. For example, the DNA information that was presented to you when you learned that the major contributor on that firearm was a female and was identified as the defendant. Now, the law does not favor one type of evidence over the other, so it's something to contemplate.
That was some common sense stuff right there.
Now,
Mm-mm-mm.
you may consider the personal credibility of any witness that took the stand. And the man is shown in your presence, in their presence and by the evidence, so this applies to the defendant as well. What was their demeanor? Did they have any reason to lie? Did the facts they testified to match the evidence? Was there any corroboration? And is what they say believable?
Somebody said she got a nice bra.
We presented several eyewitnesses that Attorney Tucker discussed. And you heard direct evidence based on things they saw and what they observed on May 7, 2019. Now, even though Attorney Tucker tried to twist their words, misquote their statements, they all stood firm in what they saw. And what was consistent between Ms. McCray, Ms. Crawford, Ms. Jackson, and Mr. Williams was that there was only one aggressor on May 7, 2019. And that was the defendant. Now, you heard testimony from the defendant yesterday.
Damn.
And, she stated that she never heard 911 tell her to not chase.
Well, I
And
ain't
then when I
chasing
went to
no.
work testimony,
Mind your business.
and the transfer,
People need to learn to mind their business.
they told different times,
No kissing.
either twice to go back to the incident location. And they told her not to follow him. But she said based on her perception and what she believed they meant was that she should follow him as long as she remained safe. Now, it is for you to decide whether there's a reasonable explanation for any inconsistency in the witness's pre-trial statements and testimony when compared to the same witness's trial testimony. You are to consider all the facts and circumstances of any prior statements. You, the jury, must apply your common sense and your reason to decide what testimony you believe or do not believe. Now, it's not a memory contest. These events happened nearly 4 years ago. And the witnesses got on the stand and testified to what they remembered that happened on May 7, 2019. And for the most part, they gave you everything. Now you can imagine, if you went to a wedding and, you went to the wedding, you told your mother, the bride dress was beautiful, the food was good, and you told her dad, they had a great open bar. The DJ was real nice. And you told your friend, the invitations that we received, they were just beautiful. Now, you may not have told each one of them all the details, specific details of what happened at the wedding. But what was consistent amongst the story is that what? I went to a wedding. And all of the witnesses were very consistent. That on May 7, 2019, Tiana McCray advised you that she observed the defendant travel around Mr. Harris' vehicle and block him in. She said that the traffic on that day was very congested on Riverdale Road. It wasn't moving. And when I asked her, was there any way after she blocked his vehicle in and detained him, could he get around her? Could he move in any way? And she said no. And what she also observed was the defendant jump out of her vehicle, irate and aggressive, and immediately run toward Mr. Harris' vehicle, screaming and yelling for him to get out of the car and cursing at him. Now, when you watch the defendant's interview, she never mentions to the detectives at any point in time that she yelled at him, that she screamed at him, and that she demanded that he get out of the vehicle. Her characterization was, I walked up to the car, I held the phone, and I said, I have 911 on the phone. And they want you to go back to the scene. And that all of a sudden, the victim just became very outraged, grabbing her and pulling her into the car. And that's not what any of the witnesses saw. And you also heard from Ms. Foster, who advised that she saw the defendant outside of Mr. Harris' vehicle punching him, being very aggressive, screaming and yelling. And you also heard from Ms. Jackson, who notified you running her off the road and other vehicles off the road, swerving in and out of traffic, which is ironic because she said the only reason she was trying to get Mr. Harris pulled over because he was going to harm other drivers on the road. She wanted other people to be safe. And then when she called up to Riverdale Road, when Jackie got up to Riverdale Road, she noticed that Miss Riverdale here had called an accident. She didn't know that she had cut Mr. Harry off before in front of him. But what she did know was that she just observed her driving very outragely. And so she pulled over because she was interested in seeing what happened. And what she saw was the defendant very aggressively banging on what she thought was Mr. Harris' window. But then what she realized was that she was actually punching him inside of the vehicle. And what Ms. Bronson and Ms. Jackson remembered was her pulling that firearm. And when she pulled the firearm, she pointed the firearm at the vehicle. And what they recall is that she immediately shot. Now, the testimony of the single witnesses believed is sufficient to establish that. So if you believe Tiana McCraney believed that she observed the defendant pull around Mr. Harris' vehicle and block him in, detaining him, then that's sufficient to establish that fact. Now, the law provides that criminal action shall be tried in the county where the crime was committed. And we did submit to you that this occurred on Riverdale Road and Forest Parkway, which is located in Clayton County, Georgia. Now let's talk about the charges. And this is where we will get into details about the facts and the evidence that was presented to you. The defendant's charged in count 1 with malice murder, count 2, felony murder, count 3, aggravated assault, count 4, felony murder, count 5, false imprisonment, and count 6 through 8, possession of firearm during the commission of the felony. Now, I know there was only one death in this case, and we charged 3 counts of murder. Now, the state of Georgia allows us to charge murder in various ways. And you don't have to pick one. If you believe that the state has presented sufficient evidence to prove that she committed counts 1, count 2, and count 4 beyond a reasonable doubt, you can enter a verdict on all of those counts. You don't have to choose one. Now let's talk about malice murder. Malice murder is when a person with malice aforethought unlawfully causes the death of another human being. Now what is malice? Malice is the unlawful intention to kill without justification, excuse, or mitigation. Its malicious intent can be formed in a moment, so it doesn't require premeditation. It can be formed in a moment. And it does not require ill will or hatred towards another. An intent may be shown in many ways. It can be inferred through the proven circumstances or by acts of conduct, or it may be inferred when it is a natural and necessary consequence of the act. So if you pull out a gun and point it at somebody, then fire that firearm, then the natural and necessary consequence is that they may die.
That is true. That is true. Boy, that lady speaking number of facts.
Now,
Oh, God.
we submitted to you that the defendant acted with malice when she chased Mr. Harris' vehicle in her Jeep. She cut off Mr. Harris' vehicle with her Jeep on Riverdale Road, cornering him in, blocking his.
Hey, appreciate the chat, man. Seriously,
When
appreciate
she
y'all.
jumped out of her Jeep in the immediately runs up to Mr. Harris' driver's back door, screaming, cursing, and demanding him to get out the car, motherfucker. She tells Mr. Harris that she will shoot him. She draws her firearm from her waist. She wraps the slide with 2 hands. And she shoots him. And you heard on the 911 call, you heard her say, "You hit my car." And she says that right before she shoots.
Oh, excuse me.
Now, she's also charged with felony murder. Now, when a person is committing a felony causes the death of another human being, irrespective of malice. So, aggravated assault, which is a felony, plus a death caused during the aggravated assault equals felony murder. So there's no intent to kill. Intent to kill for this kind of irrelevant. It's not required. So a person commits an aggravated assault when she assaults another person with a deadly weapon. And no injury is required for you to find the defendant guilty on this count. And what is an assault? An assault is when a person attempts to cause a violent injury to the victim or intentionally commits an act that places the victim in reasonable fear of immediately receiving a violent injury. And a deadly weapon. A firearm, when used the way a firearm is ordinarily used, is a deadly weapon. And that's as a matter of law. Now, the evidence that we submitted to you for the felony murder charge for aggravated assault is the defendant pointing the firearm at Mr. Herring, placing him in reasonable fear of receiving a violent injury. And as a result, shooting Mr. Herring.
There be a lot of things going on in the world, boy.
So, in the commission of committing an aggravated assault, Mr. Herring died. Felony murder. Intent not required.
She look like one of them type of women. You know what I mean? Big white women, boy, they aggressive.
And we know the defendant committed an aggravated assault because she watched the video. If you watch her in this video, shoot Mr. Herring. Now, when the defendant pulled the firearm and she pointed it at Mr. Herring, then he reasonably believed in that moment that he would receive a serious injury. And therefore, the aggravated assault was complete. In count 4, she's charged with felony murder for the crime and felony of false imprisonment.
She broke that thing down. You
Once
know?
again, intent to kill for this count is irrelevant.
No, not too many words.
And a person commits false
She
imprisonment
dumb
when
it down like crazy.
unlawfully detained another without legal authority. And false imprisonment is a felony. Now, if you recall, when
Feel like I'm in a court case.
she did not want to state that she
Journaling,
was
I'm journaling, writing the notes down. Yeah, me.
She said, "I found an opportunity and I pulled in front of him and I stopped him." So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She's not co-certified, she's not a police officer, she has no arrest powers. Nobody legally told her to stop Mr. Herring's vehicle. And you heard a lot of talk from the defense attorney that he could have jumped up the curb and drove down the sidewalk. There was no duty for Mr. Herring to retreat. And as you heard Ms. Jackson say, who drives on the sidewalk? So the felony murder in count 4 was complete
Excuse me.
when the defendant
Excuse me, chat, for all that burping and sleeping and I'm tired.
He was shot by the defendant. Again, which caused his death. False imprisonment was complete. Felony murder. Now, count 6 through 8 in possession of firearm and commission of felony. So when a person unlawfully has on his person a firearm while committing a felony. And we submit to you that in the commission of the false imprisonment, in the commission of the aggravated assault, and in the commission of the balanced murder, the defendant was in possession of the firearm. And you saw that in the photo. Murder is a felony, aggravated assault is a felony, and false imprisonment is a felony. Now, this is one of the most important parts to remember as you deliberate. A person is justified in using deadly force, force which is intended or likely to cause death or great bodily harm, only if she reasonably believes that such force is necessary to prevent death or great bodily injury to herself or a third person, or to prevent the commission of a forcible felony. Reasonable belief doesn't just mean whether the defendant believed it. The question is whether it was reasonable for her to believe it. Would a reasonable person believe it under the circumstances that she's heard in this case? Was it necessary? To be entitled to self-defense, the defendant must have needed to use this force to protect herself from an imminent threat of death or serious bodily injury or forcible felony. The problem here is that a person is not justified in using force in self-defense if she is the initial aggressor. The defendant was the initial aggressor and therefore is not entitled to self-defense. So, whatever Mr. Herring did, once the defendant cornered him, aggressively approached his vehicle, and put up that firearm, doesn't matter. He was within every right he had to do whatever he did to defend himself. But there was only one person on May 7, 2019 that was entitled to defend themselves, and it wasn't the defendant. Once again, the defendant is not justified in threatening or using force if she provokes the threat or use of force against him or herself, intending to use that threat or force as an excuse to harm the other person, is committing a felony. False imprisonment is a felony. So, once the false imprisonment was complete, when she blocked his vehicle and blocked his access, she was committing a felony. And if you are committing a felony, you are not entitled to self-defense. And once again, if you are the initial aggressor, unless you withdraw from the encounter and clearly communicate to the other person her intent to withdraw, and the other person continues or threatens to continue using unlawful force. To allow an armed aggressor who confronts an unarmed, non-threatening victim to claim self-defense when the victim struggles to disarm the aggressor is contrary to common sense and contrary to law.
That's not crazy.
On May 2nd, 2019, the first testimony of Terry Robinson. There was an initial accident that occurred on Halloween. We heard testimony that that accident did not involve the defendant. She had made no contact with the defendant. There was no argument with her and the defendant. Her vehicle was not struck. That accident had nothing to do with her. She did these polls, though she stated smelling the alcohol or the alcohol breath. She just interjected herself in situations that had nothing to do with her. Now, what she wants you to believe is that Terry Robinson was sitting in the background. He said, go, 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 go. That made for her to jump in her car, chase down Mr. Henry, lock his car off, apprehend him, and detain him. And we know that's not true. Because what you hear on the 911 call with Mr. Robinson, the only thing he said, and the only thing he said was, take a picture of the tag. Now, if we are to believe that take a picture of the tag means this, and you also heard from Terry Robinson that the defendant was already in her midst. She was already in motion. She was already prepared to do what she felt she was supposed to do in the situation. And then you hear the 911 call. And you hear the 911 operator tell her once they realize she's chasing this here. Ma'am, we advise that you do not chase or follow. And she said she understood 100%. But yet she still continued.
No, she crazy.
And you heard testimony from Ashley Jackson that she was speeding down towards Parkway so fast. Weaving in and out of traffic. I mean, she is chasing Mr. Henry. Almost causing accidents, almost running other people off the road. And you heard the defendant say that when I finally caught him, I had an opportunity. Because in her mind, she was going to stop that vehicle by any means necessary. And she did. And it's unfortunate for Mr. Henry. And you also heard testimony of the rage she had, how angry, how aggressive she was. But when she could understand, yesterday, everything was so calm. And when her attorney asked her question, she had every answer, detailed, laid out, how she was just a people person. She was just trying to do things to help. She wanted to help all the other drivers in the road. And when I was asking her questions, she came very combative and aggressive. And it was always my perspective, what I thought. No, not a white officer. This guy did not tell me to not chase. Because she knows best. And at the end of that 911 call, after she shot Mr. Henry, her whole attitude, I'm saying that he ain't. But she wants you to believe that she was concerned and she wanted an ambulance. She wanted to assist and she wanted to help make sure it was okay. She didn't care about Mr. Henry. The defendant had multiple opportunities to do something. So back to the invocation. Go back home. Not pursue. This had nothing to do with her. And the idea that she could command somebody to do anything. The only person that introduced a deadly weapon in this situation was the defendant. And what for her introducing that firearm? But the parent would still be here today. You can't hold a bear. And then when the bear turns around and attacks you, want to claim self-defense. It doesn't work that way. She should have minded her own business.
Times two.
Now, this is the real reason we're here today. Now, the law doesn't allow us to talk about Mr. Henry's background and history the defendant's actions on May 7, 2019. He would be. He saw it on the evidence. And all of the evidence points to one conclusion, that the defendant is guilty. Now, you won't be able to take back the videos and the audios and the 911 call, which is the grade. But if you want to be able to let it go again, see them, just let the baby know and we'll live with it. But this is a complex case. The defendant had no right.
Damn.
You know what?
Phone almost failed.
And so I'm gonna ask that you deliberate, that you find her guilty on each and every count in the indictment. At this time, I'm going to charge you with second-degree reckless in this case. It involves quite a bit of reading, so I can ask for your attention. But of course, you will also get a copy of the charges to take back. You are considering the case of the state of Georgia versus Hannah Renee Payne, who is charged with malice murder, felony murder, aggravated assault, false imprisonment, and possession of a firearm during the commission of a felony in violation of certain laws of the state of Georgia. The indictment you're now considering in substance reads as follows. Count 1. The grand jurors have said in the name of and on behalf of the citizens of the state of Georgia, charge and accuse Hannah Renee Payne with the offense of malice murder in violation of OCGA 1651A for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did unlawfully with the malice aforethought cause the death of Kenneth Herrick, a human being, by shooting him with a firearm. Count 2. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton, the state of Georgia, on or about the 7th day of May 2019, while in the commission of the offense of aggravated assault as alleged in count 3, a felony, did cause the death of Kenneth Herring, a human being. Count 3. The grand jurors aforesaid in the name of
A human being. And human aid.
with the offense of aggravated assault in violation of OCGA
Human
1651 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did make an assault upon the person of Kenneth Herring with a firearm and deadly weapon. Count 4. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 while in the commission of the offense of false imprisonment as alleged in count 5, a felony, did cause the death of Kenneth Herring, a human being. Count 5. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of false imprisonment in violation of OCGA
541 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 in violation of the personal liberty of Kenneth Herring did unlawfully detain Kenneth Herring without legal authority. Count 6. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of possession of firearm during the commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm a firearm during the commission of the crime of malice murder as alleged in count 1, a felony, a crime involving the person of Kenneth Herring. Count 7. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renee Payne with the offense of possession of firearm during the commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm a firearm during the commission of the crime of felony murder as alleged in count 2, a felony, a crime involving the person of Kenneth Herring. Count 8. The grand jurors aforesaid in the name of
How many things you got charged with?
the state of Georgia charged and accused Hannah Renee Payne with the offense of possession of firearm during the commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm a firearm during the commission of the crime of felony murder as alleged in count 4, a felony, a crime involving the person of Kenneth Herring contrary to the laws of said state in good order, peace, and dignity thereof. Tracy Graham Lawson, District Attorney, Clayton Superior Court, August 2019. Is to a plea of not guilty. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains for the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of a crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it's a doubt
And that is it for the day, chat.
arising from consideration of the evidence, a lack of evidence, or a conflict
Once
in the
this
evidence.
is over.
After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to find the defendant guilty. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it will be your duty to find the defendant not guilty. Bare suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, are not sufficient to authorize the conviction of the defendant. Jury, judges of law and facts. Members of the jury, it is my duty and my responsibility to determine the law that applies to this case and to instruct you on the law, which is what I'm doing. You're bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charges to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of certain facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistence with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. To warrant a conviction on circumstantial